privileges and immunities of citizens in the several states.
A person charged in any state with treason, felony, or other crimes, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up, to be removed to the state having jurisdiction of the crime.
New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislature of the states concerned, as well as of the Congress.
The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States.
The United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence.
Article 5. The Congress, whenever two-thirds of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of two-thirds of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of three-fourths of the several states or by conventions in three-fourths thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Article 6.
This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land.
And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding.
The senators and representatives before mentioned,
And the members of the several state legislatures,
and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States.
It was a truly inspired design of government that the Convention of 1787 created. And yet, as many of the delegates were aware, it had one basic weakness. The Constitution was not explicit enough about the rights of individuals. Time and again in the state conventions to which the Constitution was submitted for approval, the need for additional safeguards was urged. In the case of several states, ratification of the Constitution resulted only after assurances were given that these safeguards would be provided by early amendment. This was the first order of business of the first session of the First Congress of the United States. In September of 1789, the Congress submitted to the states a group of proposed amendments which would protect and preserve certain fundamental rights of the people against encroachment by the newly created federal government. These proposed additions to the Constitution were known as the Bill of Rights, a name which has lasted through the ages and become a living symbol of democratic free government throughout the world. As ratified by the states, these are the first 10 amendments to the Constitution.
Amendment 1.
Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof,
or abridging the freedom of speech,
or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances.
Amendment 2.
a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Amendment 3.
No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
Amendment 4.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Amendment 5.
No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war and public danger.
Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb.
Nor shall be compelled in any criminal case to be a witness against himself.
Nor be deprived of life, liberty, or property without due process of law.
Nor shall private property be taken for public use without just compensation.
Amendment 6.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which districts shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation.
To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Amendment 7.
In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law.
Amendment 8.
Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Amendment 9.
The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Amendment 10.
The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people.
Seven years after the Bill of Rights was added to the Constitution, another amendment was ratified. This limited the powers of the federal courts in dealing with matters primarily of concern to the states. Amendment 11.
The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state.
In 1804, the procedure for election of the President and Vice President was clarified by amendment. Amendment 12.
The electors shall meet in their respective states and vote by ballot for President and Vice President, one of whom at least shall not be an inhabitant of the same state with themselves. And they shall make distinct lists of all persons voted for as President, and of all persons voted for as Vice President, and of the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of government of the United States, directed to the President of the Senate.
The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for President shall be the President. The person having the greatest number of votes as Vice President shall be the Vice President.
But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States.
Then, for 80 years and one, the Constitution proved reasonably adequate to the needs of the expanding nation. This was a period of great national growth, marked by the admission of 19 new states to the Union, and more than a six-fold increase in the nation's population, from 5 to 32 million people. It was also the period when the Union was rent and torn by the war between the states. In the aftermath of that war came the three Reconstruction Amendments. The first of these is Amendment 13.
Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction.
Congress shall have power to enforce this article by appropriate legislation.
Amendment 14.
All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
The Congress shall have power to enforce by appropriate legislation the provisions of this article.
Amendment 15.
The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude.
The Congress shall have power to enforce this article by appropriate legislation.
43 years passed, until in 1913 the power of the federal government to tax incomes was assured by Amendment 16.
The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration.
The same year, a significant and fundamental change was made in the method of selecting senators. They had previously been chosen by the state legislatures. Amendment 17 provides for their direct election by the people.
The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote.
When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct.
The problems and pressures of World War I changed the thinking of people everywhere. In the United States, 2 controversial amendments to the Constitution were proposed, fervently argued, and ultimately ratified. Amendment 18, which prohibited the manufacture and sale of intoxicating liquors, was subsequently repealed. Amendment 19.
The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex.
The Congress shall have power by appropriate legislation to enforce the provisions of this article.
In 1933, the need for 2 more amendments was recognized, and they were enacted by the people. Amendment 20 modernizes certain of the Constitution's original provisions to bring them in line with the realities and requirements of the 20th century, and thus provide for a more efficient functioning of the federal government.
The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of Senators and Representatives at noon on the 3rd day of January.
The Congress shall assemble at least once in every year,
And such meetings shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day.
If at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until the President shall have qualified.
and the Congress may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President or the manner in which one who is to act shall be elected.
And such person shall act accordingly until a president or a vice president